Hi, it's Anne-Marie from Charmed Life Therapy, and today feels like a better day to be covering this case. Oh dear, I think I feel a little wee bit better. It's always a better day when there's several letters on the docket from the right side of this equation, as I think of it these days. Yeah, for some reason today I've just woken up in better form. I think for some reason the Superman theme is playing around in my head, the most recent Superman theme, even though I've not seen the movie yet. I think I feel like I've seen the entire movie based on all the clips on the internet. But yeah, for some reason the universe is playing the Superman theme in my head, and maybe that's why I've looked at these letters with a slightly better disposition. There's more bitching and moaning and whining from Blake, but there's like three letters from the combined efforts of Lina Friedman and Jackson Walker. And obviously, the big news is that there's like the Taylor Swift deposition of it all is mooted as a date and as a very real prospect. So, yeah, big props to Taylor, who looks like it is willing to sit a deposition. And I think the whole thrust of the communications that are now on the docket is like, it feels a bit like Blake Lively. We're not scared of you. We're not even scared if we don't get to depose Taylor Swift. We don't even necessarily feel like we need Taylor Swift, but we're just letting you know we have Taylor Swift. That's what it feels like. So maybe that's why I'm a bit cheerier. And maybe that's why I might be a bit delusional too. I might be slightly morphing into Blake Lively with all of it. But yeah, let's go with it. So shall we do a little bit of sharing and see where this gets us? Please do hit that like and subscribe and share if you can help me grow this little channel. Let's see where we are. So let's share this one. So let's get this one over with first. So this is the manat of it all. So let's not read all of it because much of it we know. So they're disputing now extensions and various other things. And obviously Blake wants an extension because she's gotten all the she hasn't got all the information she wants, according to her, of course, because it's kind of indefinable what Blake wants and needs, but she's not happy with the sheer bulk of documents she's been given. So she needs to extend the date to hold Steve Sarowitz's deposition, basically, and Jamie's and Justin's. I find it a little bit interesting that it sounds like Justin is going to be the last one. And is this because she feels like she needs as much information as possible before she truly confronts Justin? And I'm imagining she's going to sit in on this one, and as is Ryan. Gosh, to be a oh, goodness me, she's decided to have a snorting fit today. Do you know? You're messing with my mojo. Every time I get on this thing, I've got a dog issue. This is why hypnotherapy has become slightly more problematic since Etienne entered my life, as lovely as she is. But even so, are you okay? It's a brachycephalic breed thing. They start snorting. It doesn't mean anything nasty. It just means the soft palate is movable. So sometimes the breathing gets all a bit backed up and they panic a bit, don't you? But she seems to be all right. It tends to happen when they're startled or if they've eaten too fast. Anyway, besides that, I sound slightly manic today. I promise you that I've only had my usual breakfast, one cup of coffee and a lot of water. It must be what happens when you have Superman theme playing in your head. Anyway, so let's crack on with it. So she wants to extend the current deposition deadline from September 30th to October 10th to afford Ms. Lively sufficient time to prepare for and take the depositions of defendant Stephen Sarowitz. It doesn't actually say multi-billionaire there. That's quite unusual. Jamie Heath and Justin Baldoni, in light of recent voluminous and delayed productions of the Wayfarer defendants, of which Ms. Lively previously apprised the court. They kind of hardly need reminding of that because was it only yesterday? So she believes it won't affect any other existing dates or deadlines, including for trial or the filing of the joint pre-trial order. So the current case plan, which was modified in July, the deadline for the completion of depositions is September 30th. On July 3rd, Lively, Jones moved to amend the case plan to extend the close of fact discovery by 6 weeks to run at the same time as expert discovery. This is partially opposed by the Wayfarer defendants. So the court partially granted this request. So on September 8th, the parties jointly moved to amend the case plan to extend the deadline for the completion of expert discovery by 30 days, which the court ordered. On September 10th, the various parties met and they reached an impasse. Blake and Jones consented to this request. Counsel for the Wayfarer defendants refused to consent to this modest extension, instead insisting that they will only agree to an extension of the current deposition deadline if it is granted for 30 days for all discovery, including both party and third party depositions. Counsel for Jed Wallace and Street Relations Inc. have not stated a position yet. We should state. Right, so blah, blah, blah. I'm sick of hearing about Furry Puppet Studio Inc. versus Fallout Boy. It was vaguely amusing when they first started using it, but I'm a bit bored of it at this point. But she basically uses it to prop up her case that she has been generally diligent and the need for more time was neither foreseeable nor its fault, and refusing to grant the continuance would create a substantial risk of unfairness to her, basically. So under this court's prior orders, the parties' deadline to substantially complete document productions was July 1st. Following repeated efforts to cure deficiencies in the Wayfarer defendants' productions, Ms. Lively filed an omnibus motion to compel. So Wayfarer defendants were ordered to produce by September 2nd documents identified as 1 through 9 in the order and all other discovery, including signal communications, by September 8th. On September 8th, the Wayfarer defendants produced more than 6,700 documents, or 80,000 pages, which required more than a day for Ms. Lively to process for review that has only begun in earnest today. Based on our initial review, this production only includes 62 signal communications, which are duplicate copies of the same communications from the Tag, Nathan and Naval productions, and thus appear to represent only a handful of likely signal communications. Also on September 8th, and without first conferring with undersigned counsel, the defendants Wayfarer moved for a 1-week extension to produce what would appear to be a substantial collection of signal communications from Melissa Nathan, blah, 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 Brian and Summer Benson, which this court denied for failure to demonstrate good cause. So they brazenly still not produced the signal communications ordered by the court and are openly defying this court's prior order. It's a very difficult one, this one, as we said yesterday. Should they have already had all the ducks in a row and assumed that this was going to happen? And we don't know. But the thing is, if you can't get the information, if it's just not there yet, it's just not there yet, is it? So it does put you in a rather difficult position. I don't know what happens in this. Do they get sanctioned because they've overstepped a deadline and stuff? I mean, every day that passes, I guess it's getting worse, isn't it? But I don't know what you can do if you literally can't get hold of it, or it's difficult, or whatever it is. I mean, I think at this point they should have, handed over the phones at a moment's notice. But I think the signal thing is probably more complex with the fact that they're automatically deleted or whatever it is. So they've said they won't produce signal communications until at least September 15th, the same day that Sarowitz still doesn't say multi-billionaire, which is very surprising. Was they're being very, what's the word, succinct or moderate in their approach. So he was scheduled to be deposed on September 15th, and it remains unclear whether even that belated production will be complete. Accordingly, Ms. Lively informed the Wayfarer defendants on September 10th that the depositions of Sarowitz, Heath and Baldoni, which had been scheduled after painstaking scheduling negotiations for September 15th, Sarowitz, 18th to 19th, Heath, and 21st to 22nd, Baldoni. And what's interesting to note there is that Jamie and Justin have to sit for 2 days of depositions. And Blake's team basically said, you will have her for 1 day, and that's that. And thank you, lucky stars, basically. So would need to be rescheduled to permit sufficient time to review the Wayfarer defendants' unauthorised and belated productions. So, in light of the above, Ms. Lively respectfully submits that good cause exists for the deposition deadline to be extended briefly by 10 days to afford just Ms. Lively sufficient time to prepare for and take the depositions of Sarowitz, Baldoni and Heath. Lively also requests that this court instruct the Wayfarer defendants to make Sarowitz, Baldoni and Heath available for depositions during this modest extension. Unlike the 30-day delay sought by the Wayfarer defendants, Ms. Lively's proposed extension will not otherwise impact any other deadline, including the expert schedule just ordered by this court or the trial date previously set by this court. To the extent the Wayfarer defendants pursue, as is anticipated, well, we're getting to that, their baseless demand to extend the entire discovery schedule by 30 days, Ms. Lively respectfully requests that it should be denied. A 30-day extension would necessarily impact the current deadlines under the case plan, and it would give them opportunity to depose Taylor Swift, including the expert discovery schedule, which was just amended, motions for summary judgment, and the current trial date. Put simply, the Wayfarer defendants are entirely responsible for the scheduling conflicts that the parties now face and should not be permitted to leverage these issues as a means to extend discovery for their benefit. I think they're running scared is what we interpret from this. Ezra Hudson does not want Taylor Swift to be deposed, and Blake Lively certainly doesn't. So it says here of the signal communications, 7 are from Heath, 16 are from Wayfarer, 11 are from Abel, and defendants Nathan and Tagg produced 14 each. So yeah, so it should be 10 days and not 30 days, this extension, because Wayfarer are very naughty people who make things very difficult for Blake Lively, in essence. I don't know why she's assuming that it would affect the trial date. Nobody's saying that, I don't believe. So let's look what we've got from Wayfarer then. And it just cheers me up so much when I see these letters. I know it's ridiculous, but it does. So here's Ellen Garofalo, Garofalo, I think it is. So somebody did tell me in the comments, I can't remember quite who you were, but you did tell me how to pronounce it. And I think they said Garofalo. I think that was what you corrected me to, so I appreciate that. So, dear Judge Lyman, defendants Wayfarer Studios, blah, 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 respectfully move the court to enter a protective order directing non-parties Brianna Butler Coslow and Katie Case not to produce certain documents the court previously ordered them to produce in its September 9th order, on the grounds that these documents are protected from disclosure by the attorney-client privilege. When it issued its order, the court may not have been aware that the Wallace parties have been represented by counsel for the Wayfarer parties in this matter since December 24. Defendants now request the court modify its prior order or enter a protective order as described below. So I'm surprised this hasn't come up before, because we knew that originally he fell under that umbrella, did Jed. So he's never actually been dismissed as a Liner Friedman client. But I don't know why these things go by the by, that they didn't jump on this earlier at the time they were arguing these points. Actually, had they forgotten themselves that Jed was their client? It almost feels like, I don't know. So on September 9th, the court entered an order granting in part and denying in part Blake Lively's motion to compel Coslow and Case to produce documents withheld on privilege grounds. The order holds, in part, that Case and Coslow, agents for defendants, the agency group LLC, waived the attorney-client privilege by including Mr. Wallace on certain communication with counsel for the Wayfarer parties. However, Mr. Wallace was jointly represented by Liner Friedman, counsel for the Wayfarer parties, and thus disclosure of privileged communications to Wallace did not and could not have waived the attorney-client privilege. And there's case law cited there. A December 24th engagement letter between Liner Friedman and Mr. Wallace and Street Relations was produced to Ms. Lively on September 8th. So the letter, which is being concurrently filed as Exhibit A, clearly identifies Mr. Wallace and his company Street Relations as clients of the firm in connection with their dispute with Blake Lively and related parties. Although Wallace is jointly represented by separate counsel, he remains a Liner Friedman client. So all of these privileged communications include Mr. Wallace, but do not include Rosa Kalantari, who's the marketing person that came up with the website, Skyline Agency, isn't it, I believe. So these are the privileged communications that they now say that Blake shouldn't get to see because Jake Wallace was included in them, and he is a client of Liner Friedman. So they have this shared interest, basically, which was kind of the dispute, I think, before, that they couldn't prove that it was shared legal strategy or whatever it was. So where a party seeks a protective order on the grounds that the information sought is protected by the attorney-client privilege, that party has the burden of establishing the essential elements of the privilege. So the engagement letter establishes that Mr. Wallace has been represented by Lina Freedman since December 24. Therefore, Mr. Wallace's inclusion in attorney-client communications does not, as the order indicates, destroy the attorney-client privilege. Based on the foregoing, the Wayfarer parties and the Wallace parties therefore respectfully request the court enter a protective order and or reconsider and modify its prior order to deny disclosure of the above listed documents. Defendants attempted to meet and confer with plaintiff, who indicated she opposes this motion. Not really surprisingly, is it really? But I don't know. I don't even know if they really care whether she gets these things at this point. I don't know if they're just having fun with it all. I really don't know. I feel like there's almost a bit of a game of cat and mouse going on. And I could be wrong, but it's because I just think some of the things Lina Freedman are doing that we think, why did they do that? Why didn't they sort that earlier? This is so frustrating. These are intelligent people. Why are they, why are they doing these things? I just wonder, is all of that purposeful? And it's, it's back to this thing of they're doing something we don't know. I don't know. Or they're just, maybe they're trying to frustrate Blake into doing something stupid. I don't know. But it's interesting. So here's another letter, again from Ellen. So dear Judge Lyman, as counsel for Wayfarer Studios, blah, 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 we write in opposition to Blake Lively's motion to modify the court's case management plan and scheduling orders. Ms. Lively has not shown good cause for her proposed modification. First, Ms. Lively has known about the recently produced and forthcoming documents for a month, long before she agreed to take defendants' depositions beginning on September 15. On August 4th, Ms. Lively moved to compel a further document production from the Wayfarer parties and sought several months' worth of additional communications. On August 11th, the Wayfarer parties opposed Lively's motion to compel, but indicated they would produce numerous additional documents. Following the briefing, the parties agreed to September 15th for Steve Sarowitz's deposition, September 18th and 19th for Jamie, 21st and 22nd for Justin Baldoni. In other words, at the time the parties agreed on deposition dates, Ms. Lively knew that additional documents would be forthcoming prior to the depositions. And there's no dispute about where Jamie or Steve or Justin are going to have their deposition held. They don't seem to be debating it or making a problem about it or insisting that their physical safety is at risk by having the depositions just wherever and whenever. But that's beside the point. Second, Ms. Lively will have Mr. Sarowitz's responsive, non-privileged signal messages by September 12th. So they're saying she's lying when she says that she won't have them until the day of his deposition. Ms. Lively incorrectly claims the Wayfarer parties insisted they would not produce signal communication prior to the date of Mr. Sarowitz's deposition on the 15th. The Wayfarer parties specifically told Ms. Lively that Mr. Sarowitz's and Melissa Nathan's responsive, non-privileged signal messages would be produced by September 12th. Finally, Ms. Lively misleadingly implies the Wayfarer parties seek a blanket 30-day extension of the discovery cut-off date. In fact, the Wayfarer parties requested an agreement solely to take the deposition of Taylor Swift during the week of October 20th to 25th due to Ms. Swift's pre-existing professional obligations. Whether the court agrees to the broader modification sought by plaintiff, the Wayfarer parties respectfully request that the court modify the scheduling order for the sole purpose of accommodating third-party witness Taylor Swift, who has agreed to appear for deposition but is unable to do so before October 20th, 2025. So this is big news, isn't it, really? First off, I guess there's going to be this issue of whether the court allows this extension and what happens then if they don't allow it to accommodate Taylor Swift's time schedule. It's interesting they call her third party witness rather than non-party witness. And it also indicates that she will presumably be testifying in court should it come to court. This is a big statement to Blake. It's not even just about deposition dates and such. It's just a clear and direct message to Blake Lively herself, basically. It is my feeling about this. And it's like I say, I just get the underlying sense, kind of like the Isabella Ferrer thing and all of that. It's almost like we feel like we don't even necessarily need these people, but we're going through the motions. And it's like that thing of, well, we don't feel like we need Isabella Ferrer, but you seem to feel like you need Isabella Ferrer, but you can't have her solely to yourself. She either complies with both of us or none of us. So throws it back to the Lively camp. And I feel a bit like this with the Taylor Swift thing. It's almost like, we only really need that extension just for Taylor Swift because she's a busy lady. She's a lot going on. But there's almost this underlying current of we feel comfortable enough that even if we don't get that deposition, I don't know, maybe it's just me, but that's the subcurrent I feel like is running through it. Like there's a comfort level or something. So here's lovely Jackson Walker legal team on behalf of Jed Wallace. So dear Judge Lyman, so counsel of record for defendants Jed Wallace and Street Relations Inc. Right regarding plaintiff Blake Lively's motion to compel non-parties Brianna Coslow and Katie Case to produce documents withheld on privilege grounds. The court's memorandum and order granting in part and denying in part the motion and the Wayfarer party's letter motion for a protective order. So though represented in this litigation solely by Jackson Walker and the undersigned counsel of record, the Wallace defendants remain clients of Liner Freedman Tattleman under the terms of an engagement letter entered December 24th. The Wallace defendants' representation by an attorney-client relationship with Liner Freedman is not news to Lively. I love how these rights. Indeed, Lively knew this at least by January 23rd, 2025, after she initiated a Rule 202 petition in Hayes County, Texas, to obtain the pre-suit deposition of Mr. Wallace that she never took. In that effort, counsel for Lively represented in an email to Mr. Brian Freedman that she was informed by his office that he represents Jed Wallace. Lively confirmed her knowledge of Liner Freedman's representation of the Wallace defendants on April 7th when she filed her motion to dismiss the Wallace defendants' complaint against her in the Western District of Texas, attaching as exhibits the January 23rd email correspondence with Mr. Freedman relating to Lively's Rule 202 petition, as well as the Wallace defendants and the Wayfarer party's January 2nd complaint against the New York Times Company, filed by Liner Freedman in California Superior Court on behalf of its jointly represented clients in that matter. Despite this undisputed and direct knowledge of the attorney-client relationship between the Wallace defendants and Liner Freedman, Lively nevertheless persisted in an effort to improperly destroy a privilege held and, importantly, never waived by the Wallace defendants. Communications amongst and between the Wallace defendants, the Wayfarer parties, and Liner Freedman are protected by the attorney-client privilege. The Wallace defendants have not and do not waive that privilege, but Ms. Lively's quest for discovery from third parties unexpectedly became a vehicle for her to pursue privileged communications from the Wallace defendants. The Wallace defendants therefore asked the court to reconsider its prior order only to the extent it implicates the Wallace defendants' privileged communications and, if necessary, enter a protective order against the disclosure of those privileged communications. So signed Joel Glover on behalf of Charles L. Babcock. So that's it. That's the catch up to date so far. Whether more emails are coming through as I speak, I don't know. But it cheered me up a little bit, I have to admit. Let me just stop sharing. So how do you feel about all of that and the Taylor Swift of it all? I feel happier about it because I have had a little bit of frustration. Just I think it's difficult, isn't it, when we have a certain feeling about Taylor Swift, given that she's broken connection with Blake Lively, which for Taylor, as somebody who supports women who she truly believes have been abused in some manner, just the mere fact of her not still being in contact with Blake Lively, most of us feel says speaks volumes, doesn't it, really? So there's been a little bit of frustration as to, these people have to protect themselves, obviously, but us little emotional human beings out there tend to get frustrated about just come out and say, just come out and help, just come out and say, she's a liar, 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 pants on fire. And I didn't have anything to do with that movie. But yeah, it feels, I think emotionally, it feels a bit better now that we know certain things are being acknowledged. And it'll be in, hopefully that deposition will take place, that they'll get their extension, or Taylor will somehow manage to change her plans or do it by Zoom or something in order to facilitate this deposition. Because a lot rests, doesn't it? You imagine Taylor Swift being put on the stand and being played that footage from the end with us premiere, where it's talking about things like what influence Taylor had on the production, and that she was there with Blake throughout the whole thing, and things like that. She was pivotal in casting Isabella Ferrer, and all of these things. You imagine how that would paint Blake Lively if it comes to court, if Taylor Swift is directly asked about these things and she turns around and says, actually, I was kind of busy, in my on my Eras tour, and at the same time concurrently writing like a double album of 30 odd songs at the same time, and masterminding my business empire and trying to sleep amongst the rest of it. No, I did not have time to be a co-mastermind on It Ends With Us and take part in every little decision. I was a bystander who got we're assuming, those of us that are more team Baldoni, that I think my theory about how Justin felt railroaded by Taylor and Ryan, and he never really accused Taylor of that. But I think Taylor Swift had literally been invited to Blake Lively's penthouse. She knocks and she goes in or whatever, and Justin's there. She's been told either the meeting would be over or that he wouldn't be there at all. And she's kind of got a surprise. Blake has said, oh, let's look at this thing I've written and blah, blah. And Taylor's like, oh, yeah, yeah, I don't know why you shouldn't consider it. It sounds a pretty good idea to me. Not much more than that, maybe, or words to that effect. But even so, to Justin Baldoni faced with Blake Lively, Ryan Reynolds, and Taylor Swift all in one go, it would feel like an ambush. But I just suspect Taylor was just, I suspect she's had to take a lot in terms of what she puts up with, what she used to have to put up with in terms of Blake Lively's friendship. And she may have felt for a long time that it was more a case of to keep those people that you feel are unpredictable close to you, just in case, keep them sweet, keep them buttered up, keep them thinking there's not an issue. Meanwhile, trying to gradually distance yourself from them. I would imagine there was some element of that with Taylor. Meanwhile, Blake is making it sound as if Taylor Swift has an impact on every single aspect of the movie. It Ends With Us. So, this is fundamentally important, isn't it? This Taylor Swift's deposition, and whether she does go on to testify if it does come to court. But I think we're getting to that crunch point for Blake Lively, because I believe she will be absolutely terrified of this, because Taylor Swift is a strong woman, clearly, and she cannot be manipulated. She has to protect her own image, of course, but at heart, I believe Taylor Swift is a truthful person, and I believe, and as somebody that was the victim of, and it was SH really, SA really, wasn't it? Because he put his hands on her. Taylor Swift was the victim of a man who put his hand up her skirt. at a time when they were in the middle of taking a picture. So it had that, it's that horrible thing for a woman of something is being done to you, yet at the same time it's happening publicly, and that question goes through your mind is, can I react to this? Can I say anything? Can I make a fuss? It's a very, and I think that's something men mostly will not ever understand it, because it's all that tribal conditioning that goes through you. It's like generations of handed down stuff that is in your subconscious mind that you're not even aware of, that says, do I have to put up with this? Am I in physical danger if I speak out, say, get off or make a fuss? It's all on public, it's all in record, everybody's going to witness it. Will I be believed? All of that is going on in your mind subconsciously at the moment something like that is happening. And that's what Blake Lively will never understand, I don't think. I was something popped up yesterday that was her Blake's prom footage, and I noticed that, like, even at 17 years old and it's her prom, she's in a tiara then. And I know it's like a little thing, but she does like her crowns and her tiaras, doesn't she? And it's, I do think subconsciously that's what she believes she is, that she's a cut above, she's royalty, she's untouchable, is my feeling, and the rest of it. And so the idea of Taylor, who has more power than her and is beloved, I think that's a really dangerous concept for Blake Lively. So I think it is a big day today when we see this in writing. And I also think, regardless of what the court comes through and says, and it will be frustrating if they say, no, you can't have that extension, or you can't. But I mean, I don't see why they can't just allow for one day to depose Taylor Swift or whatever, even if they don't say, allow the dates around it or whatever. I don't know how these things work, but surely they could extend just like one day out of that period to just allow a deposition to be taken. I don't know if there'll be an argument about how fundamental testimony is to it or whatever, but I think there's possibly an interesting argument coming about it, no doubt. So we'll just have to keep an eye on it over the next few days. But it was definitely a cheerier day today in tone to me, and I think that's what tells me a lot, is that you feel so much better just reading the Lina Friedman side of things, Jackson Walker side of things, than you do Blake's, because it's that same thing of, you're not getting the bitchy moany thing, you're not getting that this was done to me and this was terrible and they're so naughty and they break the rules all the time and it's so unfair. You don't get that same thing. It's just like it's a bit like the teacher coming along and just saying, Miss Lively knew what was happening, so and she was well informed and this, and so you just feel a little bit better, I think, when you have some pushback from Lina Friedman and Jackson Walker and co. But anyway, you let me know what you thought, and hopefully that was a little bit more of a pick-me-up today and interesting and insightful. Please do hit that like and subscribe and share if you can, and I'm always happy to respond to you if you have your own thoughts about it or to get a different perspective. Okay, I will see you again soon. Bye-bye.